Hi, this is Josh Blackman. This is the 2025 Harlan Institute Virtual Supreme Court competition. This is match number 6 of the semifinal round. We have from the Creekview High School 2 teams. First team petitioners, team 20089, Hannah Romero and Bernice Hernani. And we have the respondent team 20090, Emma Favela and Angelina Hensley. We are arguing the case of Free Speech Coalition versus Paxson. Petitioners may begin whenever you're ready.
May it please the court. My name is Hannah Romero, along with my co-counsel Bernice Hernane, and we represent the petitioner in today's case. We'll be giving a brief summary of our argument in 2 main points.
Moving on to our first point, just because speech isn't protected doesn't mean it should be restricted. Significant cases like Miller, Ashcroft, and Ferber all provide insight into how courts have treated laws that govern obscenity and free speech. These cases strongly suggest that strict scrutiny should be the method used to review the House bill. Regardless of its value for minors, pornographic material does have value for adults. This idea was supported in the Supreme Court case Ashcroft v. Free Speech Coalition, which stated that there is artistic value in some of these materials. Ginsburg v. New York has often been used to justify using the rational basis review for this bill. But Ginsburg involved physical locations and only applied to brick and mortar businesses. House Bill 1181 specifically targets internet websites. Digital age verification can pose unique risks such as information retention. This is very different from simply showing ID in a person, which carries no risk.
Moving on to our second point, House Bill 1181 would not pass under strict scrutiny, as it is not the least restrictive means to protect minors. Various parental control options are available through devices and third-party applications. It should be the burden of the parents to decide what is appropriate for their children, not the burden of commercial entities. Digital age verification poses unique risks since submitting identification online can lead to issues like information retention by commercial entities or third parties. This creates a chilling effect as adults have started to avoid accessing and expressing their free speech due to fear of their identification being retained.
Okay, counsel, let me just interrupt you for a moment if I can. Why do you think the level of scrutiny should be strict scrutiny here?
Your Honor, pursuant to past court cases that have dealt with obscene content for minors, most of them have used strict scrutiny as the level of review, and that's why this should apply to House Bill 1181 today.
Just be careful. Obscene materials. Is this law only applied to obscenity?
Excuse me, could you repeat your question?
Does this law only apply to obscene materials?
It applies to obscene materials that are obscene to children, like pornographic materials.
Let me ask this question: Is all pornography obscene?
To minors, yes, Your Honor.
Okay, so all pornography is obscene to minors. If that's true, doesn't that help the government here? In other words, I was sort of surprised you're making that argument. Doesn't that help the government? You're saying this is all obscene material for minors?
No, it doesn't, because it's obscene to minors, but it is not obscene to adults.
Okay, but then how do you keep obscene material away from the kids while also allowing the adults to have it? Isn't age verification just a way of doing that?
Well, Your Honor, there are more efficient and less restrictive ways of doing that. Instead of imposing House Bill 1181 to restrict that content for minors, the government could encourage adults to use parental controls on their children's devices that are very easily available in most technology today.
Right, but I want to go back. I know that the tail in the means you want to talk about, but if in fact this case is about obscenity for minors, then why do we apply strict scrutiny? When we apply a different standard?
No, Your Honor, because strict scrutiny applies to House Bill 1181 because it deters adults from wanting to access the materials that is being blocked because it's obscene to minors.
Your Honor,
What,
when
I'm sorry, what about the Ginsburg precedent? You talk a lot about precedents. Look at the Ginsburg case. What's that case about?
Your Honor, I don't think that the Ginsburg precedent should apply to House Bill 1181 as
But my question, what was that case about? Let's just talk about that case for a minute, please.
well, it applied to brick and mortar establishments, and the one that we're talking about today is applying to internet websites. The development and technologies that have been made in the past couple centuries have made a big difference in how our laws should work.
Right. Right, but what's the difference, counselor, between going to a store and showing your license to a clerk versus going to a website and showing your license to, a computer screen? Why is that different?
Your Honor, it has a higher risk of retaining your information and personal identification as opposed to just showing your ID to a person that cannot like personally retain the information online.
But if the problem is a risk of leaks, shouldn't you focus on maybe making it more secure and not getting rid of age verification altogether?
Well, Your Honor, the issue with the leaks is not the only issue with House Bill 1181. There's also issues of it burdening adults in general. Even if there wasn't issues with leaks, adults would still be deterred from viewing a material that is within their free speech because having to enter your identification to see such sensitive material is still going to deter adults from seeing that, and it's going to have a huge chilling effect.
I want to push back just a little bit on that point. I'm looking at the text of the bill, and it seems to apply pretty heavy fines if any of these companies were to retain that information. I guess I'm not really seeing the risk there.
It has fines and like repercussions towards retaining that information, but it doesn't tell us how they could find out that they were retaining it or like leaking it in any way.
But again, it seems to go back to Justice Fenton's question, it seems you're arguing that you may not like how the law is being implemented, but Texas has taken steps to prevent these problems. Why isn't Texas taking the steps needed to make this plan possible?
I'm sorry, Your Honor, could you please repeat your question?
Why hasn't Texas done enough here? Why is Texas's law not valid? Why have they not taken enough steps to protect the data?
I think Texas's law is overbroad. Also, the rule about it only applying to websites that have a certain percentage of content being explicit. It's very hard to measure how much content on a website is obscene to minors. And especially since this is likely going to target websites in which users can upload things, the amount of content on a website with explicit material is going to keep changing. I think that the Texas law needs to be more narrowly tailored before it can be implemented.
Okay, you continue.
Sorry, can you please repeat that?
Continue argument.
Sorry. Protecting minors is important, but it still must be done in a way that won't impose a significant burden on adults. Overall, the bill's overreach risk impending free expression and places undue restriction on both businesses and adults.
For these reasons, we ask that the court overrule the lower court's ruling and rule in favor of the petitioner. We now open the court to questions.
I do have one question, kind of related to this narrowly tailored argument. If we're going to apply something more than rational basis, I don't know if you mentioned content moderation or content filtering. I'm not sure that work completely protects children there's a tendency that minors tend to be more tech savvy than their parents, and they're going to find ways around parentally imposed content moderation. Does that pose a problem for your side if that content moderation doesn't address that same degree of harm that the current age restriction does?
Well, Your Honor, I think the same concerns can also be said about this bill. There's still is likely going to be ways for minors to get around this. And when it comes to parental controls and things like that, I think that is the better solution because even within the category of minors, 18 years is a very large amount, and parents should be able to decide what is appropriate for children of different ages. So if parents are using parental controls instead of this bill being applied, then parents will not only be able to stop their children from seeing sexually explicit content, but also content that they may seem harmful because of violence or other reasons. Is there any other questions?
Your time is up. Thank you. All right, respondents, give 15 minutes. Oh boy, that was a, I feel like I'm in an echo chamber. Okay, response whenever you're ready. Let me know when you're ready to begin.
I'm sorry, can you see us?
Yeah, I can see you.
I can't see
Me?
them. We can't see you. Sorry. Hold on.
I see you.
Okay.
You good?
Yes. Sorry. May we proceed?
Whenever you're ready, 15 minutes.
May it please the court. My name is Emma Favela, along with my co-counsel Angelina Hensley, and today we represent the respondent. We'll be giving a brief summary of argument with the following 2 points. 1, HB 1181 is not restricting protected speech, along with the second point being the appropriate standard review for Texas HB 1181 is rational basis. To address the first point, HB 1181 is in no form restricting protected speech. HB 1181 requires age verification to access obscene content and pornography, ultimately to restrict minors of such obscene content until they are of the appropriate age.
Courts have continuously ruled that obscene content does not fall under protected speech and does not hold First Amendment protections, such as the Court of Ginsburg v. New York and Roth v. United States. The court held that obscenity is not within the area of protected speech or press.
Furthermore, past precedent has allowed the government to regulate obscene speech and content in public areas, such as Paris Adult Theater v. Slatton, as the court ruled that the government could regulate an exhibition of obscene material in public places. The court further addressed how the First Amendment does protect free expression, however, that protection does not extend to obscene content, particularly in public places where it might be exposed to unwilling audiences. This can be applied as social media and public platforms are exposing to minors in our case, and sometimes they may stumble upon this obscene content. Additionally, in the Court of Roth v. United States,
further held that obscenity is not a protected expression and may be suppressed without a showing of the circumstances which lie behind the phrase clear and present danger in its application to protected speech. This idea of obscenity not being protected in Roth is further collaborated.
Can I just interrupt you? You mentioned the clear and present danger standard. What case or where does that standard come from?
Your Honor, I believe the clear and present danger statute may come from either Ginsburg or Miller, if correct. Or
that's a much earlier standard from World War One, from the early 20th century. Well, let's talk about what was Ginsburg about? Let's start there.
The cases of Ginsburg, Your Honor.
What was that case about?
In Ginsburg, an owner of a shop sold 2 girly magazines that contained pornographic material within them to minors. He was then later pressed charges, and he then sued after coming back from jail. The court, because of this incident being ensued, and it was ruled in Ginsburg that obscene material cannot be considered protected speech under the First Amendment.
Right. So is this case, and I think your friends on the other side, we don't agree on this. Is this law about restricting access to minors or restricting access to adults? What's this law actually about?
Your Honor, this HB 1181 more so focuses on the restriction on
minors being able to access pornographic material, not in any way targeting adults having access to pornographic material.
So, but as a practical matter, after this law went into effect, or after this law was passed, Pornhub shut down in Texas, didn't they?
Yes, Your Honor. Pornhub did shut down in
So
Texas.
doesn't the fact that Pornhub shut down, isn't that proof that there's a chilling effect of this law?
No, Your Honor. HB 1181 in no way bans pornographic material to be accessible to adults. Adults are still freely able to access pornographic material, even with HB 1181 being upheld in states like Texas, simply through other means such as verification, where minors are able to easily access that material like adults.
All right, but isn't there the problem though that if these companies can't comply with this sort of age verification regime, does that mean there'll be a lot of speech that's been restricted?
No, Your Honor. HB 1181 merely simply targets websites that hold 1/3 or more material that pornographic websites that contain more than 1/3 of pornographic material on them. Other it should be clarified that obscene material such as pornography is not protected by the standard in laws of the United States, meaning HB 1181 is in no way infringing on First Amendment rights of freedom of speech. That is not what HB 1181 is trying to restrict.
Okay, you may continue.
Also in Ginsburg v. New York, the court's central holding is that the regulation of the distribution to minors of speech obscene for minors is subject only to rational basis review.
In our case, the government has a legitimate interest in protecting minors, as seen in Prince v. Massachusetts, as it states that the state's authority over children's activities is broader than any other actions like those of adults.
Additionally, the appropriate standard of review for Texas House Bill 1181 is rational basis, as the government is in no way infringing upon protected right. As the petitioner may try to
Can I pause you there just for a second? If you're saying that there's no infringement of this right, but for adults who have to provide their driver's license or other form of governmental ID, you heard your friends on the other side argue that they might be hesitant to do so. They might decide not to do so out of concern for data privacy, that there might be a leak of this information. Doesn't that seem like some sort of burden at least?
Your Honor, and as our friends from the other side did state that they may have trouble coming up and giving their information, it is not it's not burdensome as we can look into the brick and mortar stores, as this has already been happening. As for example, when purchasing alcohol, you must show your identification, which hasn't been an issue, and it also has in other situations such as entering clubs. You show that you're a verification. This is nothing new. This is nothing new that is would be burdening adults, as they have been doing this.
But on that point, something does seem a little bit different to me between the brick and mortar store and what's happening here. I have to, or someone would have to upload their license, and it's a digital scan. They might not know where that data is going. Doesn't that seem a little bit different than you just flash your card to the clerk at the grocery store and then no one is retaining that information?
No, Your Honor. In our case today, HB 1181 actually penalizes these websites that do give this private information to other parties. This would not cause a chilling effect in whatever way, and is not different from a mere brick and mortar store, since, well, this information is kept private and it is kept safely. And if there is a breach of this information to other websites or other parties, these websites do get penalized under HB 1181.
Thank you.
In our case, the government has a legitimate interest in protecting minors, as seen in Prince, Massachusetts. As it states in other states, the court does have authority over children. Miller v. California used a three-prong test to identify obscene content, and if it was found obscene, then the court may regulate it. Under this test, pornography from an average man would appeal.
Hi, can I ask a question, please?
Yes, Your Honor.
Is this a regulation of obscene speech for adults, or is this law a regulation of obscene speech for minors under Miller? How do you sort of reconcile those precedents?
Well, Your Honor, in HB 1181 is primarily targeting obscene speech for minors. Although pornography is still a item that is considered obscene. We are not trying to target adults because this law is focusing on the compelling government interest of keeping the welfare of children, and HB 1181 is trying to be a way to suffice this compelling government interest in protecting primarily the welfare of minors from obscene materials such as pornography.
Okay, you continue.
We pray the court rule in favor of the respondents, and the court is now open to questions.
I've got another question just kind of on this. You heard the other side mention content filtering as maybe one of the ways that this could be done in a more narrow way. Leave it up to the parents to decide what to do. Why isn't that sufficient to do the content moderation of there's a lot of briefs that say that technology has improved in the past 2 decades. Why isn't that good enough?
Your Honor, firstly, to address our friends from the other side, they did state that they think that the parents should be up and to make that decision on whether their children should be viewing the obscene content. However, when we look into the case of Prince v. Massachusetts, the court held that the government has a broad authority to regulate the actions and treatment of children, and that parental authority is not absolute and can be permissible and restricted if doing so in the interest of a child's welfare. In which, in this case, the government has that compelling governmental interest over their parents' decisions as they try to protect minors from such obscene content until they are of the right of age.
I might follow up just one quick question of if this court were to apply a standard greater than rational basis, does that mean your side loses?
No, Your Honor. Both sides, especially in the most recent oral arguments made by the Supreme Court, the idea that there is a compelling state interest in our case today, and both sides do agree to this. It's our side our HB 1181 is narrowly tailored to meet this compelling government interest in the least restrictive way, which is why it would be the most beneficial and most suffice way to be rational basis. But both sides do agree there is a compelling state interest in today's case.
What about Brown versus EMA? Is that a case that you've thought about?
No, Your Honor.
Okay.
Or
that was a case where the state restricted the sale of violent video games, as you have to have a parent who had to basically approve the sale of a violent video game, and the court held that law is unconstitutional. If the state can't restrict the sale of violent video games, why can they restrict the pornography?
Your Honor, in the court of that case, I think that there was a greater interest of violence presented to minors rather than this obscene content, in which if in this obscene content, which they hold different standards and different sorry, Your Honor, they have different standards and different reasons for that restriction, in which in that case, the one that you mentioned, they had a greater interest to prevent that violence from being shown to children rather than in this content, it's obscene content.
Okay. You may proceed, Counselor.
Is there any more questions being asked, Your Honor?
I don't have any. Justice Fenton?
Well, Your Honor, we would also like to address their petitioners' briefs, that on page 7 of their brief, they had stated that speech is unprotected, just because speech is unprotected, that it doesn't automatically mean that it can be restricted. However, when unprotected speech poses a harm towards minor, the speech becomes reasonably related to the government and they have the right to restrict due to the government's compelling interests. This further goes back into our argument in which why the government has the compelling interest to protect minors from such obscene content, as we can see from Ginsburg v. New York and from Princeton, Massachusetts, as they both hold the protection of minors from obscene content.
Okay.
If there are no further questions, Your Honor, we pray the court rule in favor of the respondent in today's case.
Very well. Thank you, Counselor. Okay.
Thank you.
You have rebuttal time? Go ahead whenever you're ready. 5 minutes.
May it please the court, opposing counsel said rational basis review should be applied, but past precedents suggest using strict scrutiny. They have reviewed laws heavily similar to House Bill 1181. These cases are Ashcroft 2, Sable, Playboy, and many more have tried to restrict obscene material being seen by minors and have not passed the review in strict scrutiny. So why should House Bill 1181 be different?
Opposing counsel also mentioned things like buying alcohol and gambling as examples of also needing to present identification in person and also online. But the difference between that and needing to present your identification to view things that are considered explicit content is that once you present your identification for things that are explicit content, your ID can now be attached to very sensitive content that most adults would not want people knowing that they're viewing. Opposing counsel also said that this bill is about protecting minors and restricting minors' access to this content, but just because that is what it is about does not mean that adults are not being affected. Adults are not directly being they are being restricted in that they need to present their identification, but despite the fact that they still have access to it with their identification, a chilling effect is still created. They are being deterred from viewing something that is allowed within their free speech.
Let me interrupt. Yeah.
Excuse me, could you re-ask your question? We had our volume down.
I think there's some delay. Okay.
Excuse me, Your Honor. Could you re-ask your question?
Sure. My question is, though, I realize that you're very much concerned about the rights of adults to access their pornography, but what about the children? And states have considered this issue, they've thought about it, and they decided it's the best way to protect children from pornography. Why isn't that good enough for us? Why should we interfere?
Your Honor, it's because there are less restrictive means than opposing the burden onto adults rather than
Your Honor,
what are those less restrictive means, Counselor? Can you tell me what those are?
Well, as we said before, there are parental controls that many technology companies and internet service providers have readily available for parents to use. And as I said earlier,
But again, what if parents don't use them, or parents don't care, or the parents are using porn themselves? In other words, doesn't the state have the power to step in and protect children where parents can't?
Yes, but it is the parents' personal burden to protect their kids from obscene material online.
And, Your Honor, if the state's interest is to protect children, then instead of House Bill 1181, which is also imposing a chilling effect on adults and creating this huge burden, maybe instead bills could be made to make it so that adults have to use parental controls on their children's devices. And that way, as I said earlier, adults can not only block their children's access from sexual and explicit material that's being blocked by this bill, but adults can also block access to, again, violent material or things that they think are not suitable for their children to be seeing.
Okay, Counselor, you can wrap up.
No, as I was saying, a huge chilling effect has been created on adults, and something that they are allowed to see under their constitutional rights, under their free speech, is they're being deterred from seeing it, and that is why we ask. Because of those reasons, we ask that the court overrule the lower court's opinion and rule with the petitioner in today's case.
Okay, very good. The case is submitted. All right, thank you so much. Congratulations to both teams. I know that was a lot of work and it was very hard. I try to run this competition the same way I'd run a moot court competition in law school. So it's very fast paced, a lot of interruptions. I am challenging you at every step to see what you know, what you don't know. And it might seem a little bit uncomfortable, maybe a little bit rude, but it's designed to simulate what it looked like in the real world. And you're all high school students. You've done very well for yourself. You're very, very proud. Let me just give some comments and feedback, and maybe my friend Robbie will give some feedback as well. One of the hardest things about giving an oral argument is transitioning from prepared remarks to impromptu remarks. And I think a lot of the teams have very good prepared remarks, but when those sorts of run out, you don't really have stuff to say. So if you know you have 15 minutes, you should prepare to have at least 15 minutes of material to read. You won't get to all of it, right? But in the event that for whatever reason the judges aren't asking questions, might be a cold bench, as they say, you need to have enough to sort of fill in your time. Um, I know it's tricky over Zoom and there's always tech issues, but you have to learn a talent that when a judge starts speaking, you have to close your mouth immediately. You have to stop talking right away. It's very hard to do and very tricky, but you have to figure that out. Because what ends up happening is it's crosstalk where I'm talking, you're talking at the same time, and no one's listening, and then you don't hear the question. So when you see my mouth open, you stop. It's very tricky. Any question that's asked, your response should be yes, Your Honor, or no, Your Honor. You can say yes, Your Honor, but, or no, Your Honor, but, or yes, Your Honor, that's generally true, but in this case, or so on. Pivot, but you have to at least start with a yes or no answer. That way, I know if you're answering the question. Very often, I wasn't sure if you've been answering my question. Another related issue is after I finish asking questions, I say, okay, you can proceed. Figure out how to naturally transition back to what you want to argue about. I felt like some of the transitions were a little bit abrupt and you kind of got a little flustered. And I think with both teams, you sort of finished with time left on the clock and we had asked for questions, but again, you should have some stuff to sort of keep discussing. With regard to the substance, I think you both have a good command of the cases. It's sort of very tricky to know, why you apply one tier of scrutiny in this case, a different tier of scrutiny in another case. I think you should have just a better strong sense of why this test or that test applies. If I ask you about a precedent you don't know about, you can say I'm not familiar with it, but then I'll give you the facts you sort of figure out on the fly. That's a very hard thing to do, and I did that a couple times. Um, when you're thinking about this with when you're thinking about the age verification, sort of this least restrictive means approach, uh, just have more sense of why this technology may not be as permissive as otherwise. In other words, why this tech may not be as effective. Kids can get around it. There might be parents who don't care. Just sort of be aware of those different issues. That's really all I have. Robbie, anything that you want to add?
Not particularly. If I was really impressed with the cases that you knew. It's clear that both teams prepared a lot. I mean, some of the questions that Professor Blackman and I asked, they were ones that were also asked during the actual oral arguments, and so I think your responses to that were really impressive. These are hard questions. Um, yeah, I mean, just a very impressive competition.
Okay. Do you have any questions for us?
No, sir. Thank you.
No, sir. Thank you.
Thank you.
Thank you.
Okay.
Oh,
And all, if you ever in
Wait,
Houston,
Lucy?
come to my law school and just for a class, or
hola.
we're gonna crosstalk. Babe, if you're ever in Houston, it's not too far from where you guys live. You're welcome to visit my law school class anytime, I promise. Okay. Thank you all so much. Take care. This one, yeah. Okay. Bye.